Hi, this is Seth Ward, and this is an introduction to Hadith and Islamic law. I'll begin by setting the stage. We're talking about a generation or two after the Islamic conquest, the time of the Umayyad caliphs, approximately the year 680 through 700. The Islamic world had expanded to Morocco, to the Indus River Valley, or nearly so. Abdul Malik, the caliph at that time, had put down the revolts in Iraq, the revolts of the shi'as, and so on. And most of the people who had known Muhammad personally had already died. People knew people who had known Muhammad, and there were in fact some people who were alive who never met anybody who had known Muhammad directly. Question was asked, how does one do Islam? We no longer had the living tradition of the people who had already done it that way. Well, there are a couple of sources that were used at that time. The most important one, of course, was the Quran, the basic source of Islamic law revealed over 22 years. The earlier sections of the Quran were more poetic, but after the Hijrah in 622, there was much more legal material. Other sources for law, for things that were not explicit in the Quran, or for that matter, for understanding the Quran, included all sorts of things. Traditional Arab practice, the practices of Muhammad or early Muslims, the practices of Christians and Jews. In fact, there's a very famous a statement of Muhammad, a hadith, that says, recite from the Jews and don't worry about it. And the recorded decisions of early judges in the early Islamic period. All of these were referenced by Muslims to say, well, here's how we decide, here's how we understand what the Quran says. Abdul Malik reformed a number of things. He introduced more Arabic in the administration of the empire. He reformed the coinage. He built the Dome of the Rock, shown here as a manifestation of the power of Islam, and I believe also as a manifestation that Islam had replaced Judaism and Christianity, both by its location and by the inscriptions, which talked about God having neither a partner nor begetting a son. Many things emerged to describe how Islam should be practiced. We're going to talk about the beginning of law schools. The earliest one to emerge was the practice of Iraq as codified by Abu Hanifa, who died in 767. Abu Hanifa had a preference for Iraqi tradition. He would give some of his own opinion as to what to do, and he would use something which was called qiyas, logic, or logic by analogy. Today, the Hanafi school is in fact quite important. It was adopted by the Ottoman Empire. It was adopted by the Mughals and most importantly by the British in South Asia, and has a lot of standing in Central Asia. A second school to emerge in the century or so after Abdul Malik's death, and the half century or so after the beginning of the Abbasid rule, was the school of Medina, usually named after Malik ibn Anas. Malik died in 795. He was the author of a very important collection, early collection, of sayings of Muhammad, and in this collection he often says, and this is what I think is the best opinion. Ra'i, meaning opinion in this case, what I see as correct. There were some other traditions from Hijaz, from the areas around Mecca and Medina, and the contemporary provenance of this, the places where the Maliki school is found in North Africa and Upper Egypt. Interestingly, today, some African Americans, remembering that their ancestors were slaves who were brought from Western Africa, have preference for the Maliki school. The most important school for the development of Islamic law is probably Muhammad ibn Idris al-Shafi'i's school. He was born in Gaza, died in Egypt, and the Shafi'i idea was, the idea of a Shafi'i was that Quran, Hadith, Qiyas, and Ijma, consensus, would determine how to do Islam. First look in the Quran. If it wasn't in the Quran or you didn't know what the Quran meant, looked in the Hadith, and this was very specifically the Hadith Nabawi, the Hadith, the recorded conversations of Muhammad, or the recorded conversations about what Muhammad had done, or the records of what Muhammad had witnessed without raising any objection to what Muhammad said or did or agreed to tacitly. Failing that, or I should say, if that did not give enough of a response, then reasoning by analogy, and this came to be very specific types of reasoning. There were a number of principles which you could use, and consensus, and a lot of argument about who exactly had to agree for consensus. The Shafi'i school in earlier times was dominant in some of the parts of the Arab-speaking parts of the Ottoman Empire. Today, it's mostly in Southeast Asia, in Lower Egypt, and in the Indian Ocean area. Finally, very important today for a very prominent place where the Hanbali school is practiced, the school of Ahmad ibn Hanbal, who died in 855, represents an urban Baghdadi tradition. Ahmad ibn Hanbal preferred Hadith. He preferred the practice of what Muhammad did, had a very limited role for reasoning. His main law book, the one that's most commonly used today, is a collection of hadith in which he doesn't even organize them according to topic, merely by the transmitters. The most important place where Hanbali law is practiced is in Saudi Arabia, but the influence of the Saudis has been extremely important in marketing Hanbali approaches all over the world. There are a number of Shia law schools. The most important branch of the Shias are the Twelvers, and we'll talk about them in a moment. There were some who were Fivers. That is, they agreed with most Shias about the first four Imams, Ali, Hassan, Hussein, and Ali Zain al-Abidin, the son of Hussein. And they split with respect to the fifth Imam. The Ismailis split off with the seventh Imam. This was Ismail, who died before his father Ja'far as-Sadiq did. The Fatimid dynasty, the infamous assassins of the Middle Ages, the Aga Khan, all of these are offshoots of the Ismailis. The Druzis, too, are an offshoot of this stream. By far the most important Shia law school are the Imamis, the Twelvers. Most of the Shias we hear about today in Iran and southern Iraq and in Lebanon and various other places are Twelvers, Imami Shias. The law school, when we're talking legal materials, is called Ja'fari, and it's named after Ja'far as-Sadiq, the sixth Imam, who died around 765. Ja'far's son, the one who succeeded him, and his descendants went on to the 11th Imam. The 12th Imam disappeared around 874. Up to 939, he sent ambassadors, but in 939, the chain of transmission, as it were, of the imamate was lost, and there were no more ambassadors to be sent. So the question was asked in the Shia tradition, if imams were the ones that guaranteed law rather than the tradition of what Muhammad said, what would you do? And I'll have the name of some of the books in a moment. But here we have the basic split. Sunnis follow the Sunnah, the traditions of what Muhammad did or said or agreed to. Imamis, the Shias, follow the traditions of what the Imams taught and charismatic leadership and how that affected everything. There were other law schools. Ibn Hazm in Spain in the 900s was the most famous member of the Zahiri school. They worked primarily on what was obvious. And the historian Tabari, died around 923, was the founder of what's sometimes called the Jariri school or the school of a Tabari. It's actually notable because it was very liberal. It had attitudes towards the role of women. Jariris held that women could be judges and that women could lead men in prayer. Tabari is the most famous collector of historical traditions and was the most famous collector of traditions about the Quran. His massive Quran commentary includes most of the early statements that we know today that he had come across. So it's not an unimportant guy. However, his law school had no traction and died out, and today is not considered to be orthodox. Shafi'i's concept that hadith, reports about what Muhammad said or did or agreed to, would be the basic foundation of Islamic law and the basic tool to understand what the Quran meant, meant that Hadith became ever more important. And in order to guarantee Hadith, it was recorded and collected not only by the text of what Muhammad said, but by a chain of transmitters. The chain is called isnad, the text is called the matan. An early transmitter, not very important historically, but extremely important as the person who knew Muhammad, who transmitted these things, is named Abu Huraira. And he is supposed to have transmitted 5,374 distinct hadiths with 1,236 separate matans, an enormous number. The most important collector lived and worked in the generation after Ahmad ibn Hanbal. His name was al-Bukhari, and he collected 2,602 distinct matans, distinct traditions, in the form of not all 9,082 different hadiths. These are the traditional numbers that one will find in the literature. Bukhari classified the traditions according to legal context. So he'll put all the traditions about prayer together, all the traditions about purification or pilgrimage or whatever it might be, follow one after the other in his book. And the traditions which have nearly identical texts will usually be together if he's quoting them for the same purpose. If the hadith covers two separate things, for example, suppose Muhammad is supposed to have said something which reflected both on prayer and fasting, you might have the tradition in both places, both the chapter on prayer and the chapter on fasting. Most hadiths go back with a chain only to the friend of Muhammad. This is called a sahabi, saying that he saw the Prophet of God doing this or that. Sometimes they go back to Muhammad, who said that God said such and such, and this is called a hadith qudsi. In addition to the sahabi, we also have a debate about the talabi. Those are people who did not know Muhammad but knew sahabis, and all of us are talabin. We don't know anybody who ever knew Muhammad. We only rely on people ahead of us. Transmitters are also ranked not only by how close they were to Muhammad, but whether or not they actually met the people from whom they recited or to whom they recited, or how reliable they were, either in terms of literary reliability, did they recite the exact same text, or in terms of religious reliability, were they upstanding, honest, forthright people, and were they men of piety and religion? There are a number of searchable hadith databases. The one that's on your screen is easy to search, although I don't know whether the way I'm saving it will give you a live link. The two most important early collections of hadith were by Malik, whom I referred to before, and Ahmad ibn Hanbal. Malik wrote a musannaf, a hadith collection that was organized according to subject, and in fact, generally Malik says what he thinks the law is on these circumstances. The musnad is the opposite. It's according to the companion of Muhammad and gives no indication about what the tradition is. Al-Bukhari, whom I mentioned before, and Muslim ibn al-Hajjaj wrote collections which are generally called the Sahihain, the two sound collections. They only have traditions which have sound transmissions. They only have traditions which are considered to be the top standard. There are lots of stories about Bukhari, how he prayed every time he decided to collect a tradition or reject it, and so on. And Bukhari gives jurisprudence in the form of chapter headings. So his chapter headings would be about the admissibility of so-and-so, or that you must do this and that before you pray, and so on. Muslim organized it the same way, but without the rubrics. In addition to the two strongest collections and the two earliest important collections, There were 4 that were considered to be good as opposed to sound: Tirmidhi, Ibn Majah, Abu Dawud, and Nasa'i. And we have a whole body of shi'a hadith collected with the idea of functioning not only to have prophetic hadith from Muhammad, but also hadith from the Imams. Statements of Halil were put together in a book called The Way of Eloquence, a book that you can find online. And at about the same time that the ambassadors from the hidden Imam began to disappear, Al-Kulaini put out a book called Al-Kafi, that which is sufficient. Ibn Babawai, sometimes you'll see his name is Ibn Babuya. Man la yakhduruhu al-faqih. This is the book for somebody for whom there is no jurisconsult of the age, no imam, and could look at this and have what the previous imams have said. In a later time, a Shia gentleman named Atusi published 2 collections of hadith called Al-Ibtisar and Ta'dib al-Ahkam, both of whom, all 4 of these books, are the major works for the Ja'fari, the Shia hadith school. We also have popular hadith, and in terms of popular piety, rather than using Bukhari, many Muslims in the Middle Ages would learn 40 hadith, for example, Nawawi's book, or they would learn Mishkat al-Masabih, a very important collection by Hussein al-Bahawi. Nawawi is actually an instructive guy. He was a Shafi jurist, and his career reflected the expectations of many people who were part of the ulama, the learned cadres of society. He not only wrote the popular collection of the 40 most important hadith, but he wrote a commentary on the Sahih of Muslim, and he wrote Minhaj al-Talibin, which was a kind of handbook for Islamic law. The way he wrote it was that he summarized an earlier book by al-Rafi, and he also wrote commentaries on Rafi's commentary to Al-Ghazali, a very important philosopher and jurist who died in 1111, Al-Rawda fi Mukhtasar Sharh al-Rafi li Kitab al-Wajiz lil-Ghazali, Rafi's commentary on Al-Ghazali. So you can trace forth how the ulama wrote compendia that were based on commentaries that were based on other compendia and so on, and moved forward the idea of Islamic law. Nawawi's book, Minhaj al-Talibin, gives you the most important rulings, but will sometimes give you 3 or 4 different opinions by different jurists as to what is the proper thing to do in a circumstance that has to do with prayer, or with inheritance, or with business, or with money changing hands, or with piety, or with marriage, or with any of the other things that would have happened in Islamic law. I think the only thing that I can add on this slide was that the Shias, the Ja'faris, generally use Quran, the Hadith of Muhammad, the traditions of the Imam, and rather than calling the logical principles qiyas, analogy, they called it aql or mantiq, which has to do with logical reasoning, or with aql means intelligence, with using your mind. In emphasizing, even here in the case of law that was following hadith and tradition, how one had to use one's intellect a little bit more freely and a little bit more based on the charismatic opinions of the jurisprudence. Having said that, when I read Shia compendia, they read almost exactly like the Sunni compendia in terms of how they do things out. And I don't know that there is, at least at an early stage of analysis, I don't know that there's that much difference between the way they're set out, except for quoting what the Imams said. Now, the idea of Islamic law was that using this material, any particular action by any particular agent would have one of 5 categories. It might be required, and some things would be required on the individual, some would be fine and required, but only on one person in the community or on the government. There are also things which are a little bit less They are called sunnah mu'akkada, confirmed tradition, and they are required, but they're not required as strongly as if there were Quran and unambiguous Hadith basis for them. Some things are commendable, the Arabic mustahab. These things are things you ought to do, and you are praised if you do them, but you are not punished, as it were, for not doing them. Most things are allowed or neutral. Then there are the two opposite categories. Some things are reprehensible. You are not praised if you do them. You lose praise, but it's not like you are punished as if you do the prohibited, which you are punished for doing them, as well as being praised for avoiding them. One final category, the Facebook, by the way, is a reference to a Facebook discussion of the 5 categories that I thought was pretty good. There's one further category which we'll call King's Law. Since Islamic law didn't necessarily bind the kings in practice, there was a branch of Islamic law called al-ahkam al-sultaniyya, the laws of government. The most famous book was by al-Mawardi, who entitled it al-ahkam al-sultaniyya. There are also many, many laws and guidebooks for the market inspector, required both by the Quran and by Islamic tradition, but the muhtasib, the market inspector, made up regulations in order to keep the market safe, in order to protect people, in order to keep weights and measures standard, and so on. And kings and market inspectors would often have their own ideas, sometimes very well-based and well-grounded in shari'a, and sometimes not. The conflict between the law of the king and the law of the shari'a is not particularly germane to our period, but in modern times, people like Noah Feldman have argued that the arrogation of tyranny by Arab and Muslim monarchs and the cancellation of Sharia underlies the notion of reinvigorating Sharia in the late 20th and early 21st century. Finally, one sometimes hears today about the specific punishments for theft, fornication, false accusation of fornication, and a few other things. The cutting off the hand of the thief, the stoning for fornication, and so on. This category is called had, and most things don't have specific punishments. The qadi, the judge, either gives lashes or imprisonment or fines. But these have very specific types of punishments. Thank you very much. In this PowerPoint, I will be introducing Hadith and Islamic law. I'm starting from this situation that occurred about a generation or two after the Islamic conquest. Islamic conquest, the death of Muhammad, 632. Many lands were conquered around 640, 645. By 700, the Islamic world had mastery over a large swatch of land from Morocco to Iran, north to Saudi, to Central Asia, south to the borders of the Sahara. Abdul Malik had in the 690s pacified what we today might call the Shia revolts. Hussein had died on the battlefield of Karbala in 680. The remnants of the anti-Umayyad fighting had been pacified by Abdul Malik and by Hajjaj ibn Yusuf, and the world, the Islamic world, was ready to ask questions. What does it mean to be a Muslim? Some of the answers had to do with spirituality and mysticism. So, for example, we have the beginnings of Sufism in Hassan al-Basri. We have the beginnings of some sort of more mystical apprehension, light poetry about prayer, Islamic-style poetry, as opposed to pre-Islamic-style Arab poetry. We have other responses, but today I'm going to focus on sources and precedents for what became Islamic law and practice.